Hello, everybody, and welcome to today's webinar. Today, we are talking about making a will in BC, a step-by-step guide. I am your host and moderator, Paula Price. I will be introducing our panelists in just a few minutes. You know you're in the right place if what you're looking for is information, the step-by-step process of making or updating your will. What you can expect today, we've got 60 minutes together. We will be providing answers to your questions, not legal advice. If what you're looking for is legal advice, in other words, the law as it applies to your particular set of circumstances, we invite you to reach out to a lawyer or to a notary. You're welcome, of course, to reach out to our speakers today. Their contact information is on the screen, and the information that we share is, of course, current as of today. We would like to acknowledge, as the People's Law School team, we are grateful to work on the unceded traditional territories of the Musqueam, Squamish, and Tsleil-Waututh nations, whose peoples continue to live on and care for these lands. And we invite everybody to reflect on where it is that they are joining us from as well today. We would also like to thank our funders, the Department of Justice Canada, the Law Foundation of British Columbia, and the Notary Foundation of BC, whose funding makes production of these webinars possible. And then finally, of course, we would like to thank and welcome our speakers. I will introduce them each as they appear on the slide. So we'll start with Michael Scott. Michael Scott is a lawyer with Clark Wilson, which is a law firm in Vancouver, and he has an estate planning practice. Welcome, Michael.
Thanks, Paula.
We'd also like to introduce Notary Public Clinton Lee. Clinton works with David Watts Notary Corporation. He is also joining us here today from Vancouver. Welcome, Clinton.
Thanks, Paula.
Wonderful. And we also have lawyer Brandy Stocks. She is with the Public Guardian and Trustee in the Child and Youth Services Division. Welcome, Brandy.
Thanks so much, Paula.
Thank you. And I'd just like to share with everyone our panelists today are joining us for the 4th consecutive year. We've done this webinar for Make a Will Week since 2020, so it's such a thrill to have them here. You're in for a treat. The recordings, if you're interested, of these webinars are on the People's Law School website, and they have been viewed approximately 5,000 times. So these resources that are being created are lasting, not only for everyone who's here live, but also for people who find us afterwards. So thank you, thank you, thank you. We're going to start with our prepared questions. And the first question is for you, Clinton. And the question is, how do you know if you are somebody who should make a will?
That's a great question and a very good general start point for talking about wills. So there are various scenarios where you should be making a will. One of the more common ones usually is of age. Once you reach a certain age and you are acquiring or have accumulated assets, such as a home, or have purchased a home, or have other substantial assets that you want to leave behind to a loved one, that's where a will can be a good mechanism for you to transfer that benefit to them once you passed away. Another common one is amongst young families. Once they have a child, they start of a child, and they start thinking about guardianship. That's definitely another area where a couple may decide to create a will. But those primarily are the two main ones where I've seen as my clients have come in and sort of we've inquired about why they're wanting to create a will is usually under those two things where, you know, they're at a certain age where they want to make sure that their loved ones are taken care of and that their children are also taken care of in the scenario where both parents may not be here.
This next question is for you, Brandy. And the question is, when is the best time to make or update your will?
Awesome. Thanks so much, Paula. I'm happy to be here today to talk about estate planning. So when should you make a will? The good news is anytime is a good time to make a will. The common wisdom is, and Clinton just touched on this, you know, you make a will after a major life change, like marriage, having kids, moving to another country. And I think that's great. But I also think you want a will no matter what. I don't think you need to wait for a milestone. Just make a will and make a will that contemplates future events. So like Clinton said, you want to make a will if you have assets. bank accounts, a priceless Barbie collection. And if you have any desire for those assets to go to a certain person, maybe you want to leave your Barbies to your grandkids, maybe you want to leave your parrot to your sister, and you want to make a will if you want to appoint a specific person you trust to administer your estate, to be your executor. Make a will if you have minor children, like Clinton said, and you want to decide who their guardians are, but you also want to decide who is the trustee of the funds that you leave them. And similarly, you want to make a will if you have minor grandchildren and you want to leave them money and decide who holds that money in trust for them. If you want, for example, your adult child to be trustee of the 15,000 you want to leave your minor grandkid, you have to say that in the will. That will not automatically happen. So the second part of the question is, when should you update your will? Basically, whenever your financial or personal circumstances or wishes change. And I think you should review your will every few years to ensure that it still reflects your wishes. So, for example, you may have named your brother trustee for your grandchild in your will, and then maybe your brother moved to Switzerland, and it would no longer be a great idea for him to be trustee. So you may want to update your will. Maybe you made your will before you had grandkids, and now you want to leave them a fund for university. You may also want to update your will if you get divorced or separated. Your will would still be valid if you get divorced or separated, but any gifts to your former spouse would fail, and an appointment of your spouse's executor would no longer be effective. So even though the rest of the instructions in your will can be followed, you still may want to update your will to change your alternate executor, add another alternate, etc. So really, any time is a good time to make a will. And I'm sure that Michael and Clinton would tell you that if you draft carefully to begin with, you really reduce the likelihood that you have to update your will later on, as you may have anticipated most changing circumstances.
Beautiful. Thank you so much, Brandy. This next question is for you, Michael. And noting that this is all about making a will, what can you expect to see in a will document itself? What does it look like? What does it contain?
Sure. Hey, everyone. Well, what can you expect to see in a will? As a starting point, I look forward to seeing a will that sets out a bequest of a Barbie collection. So that will be an interesting one.
Priceless.
What can you expect to see in a will? A lot of legal jargon as a starting point that you'll have to work through and talk to your professional advisor about what all the terms mean. But to break it down a bit more, you'll see that there would almost always, if not always, be some provision around who you'd be appointing as executor of your estate, being the person that you're giving the authority to manage your assets and carry out your wishes. So that's one. Both Brandy and Clinton have mentioned guardianship. So if for someone that has minor children, we would almost always see a guardian appointed in their will to say, if I die, here's who's going to step in and be the care provider for my minor kids. So that's two. You'll always have beneficiaries listed out in your will. So based on whatever the will maker's wishes are, you'd lay out some kind of scheme for how your assets are going to succeed down to your beneficiaries in percentages, or if it's going to be fixed cash amounts or some combination of the two. That would be laid out in your will as well. And then in addition to all of that, there would be a bunch of language to give your executor all the powers that they need in order to deal with the administration of your estate. So things like powers to deal with your investments and deal with taxes. And there might be some provision around liability. So oftentimes we would have some provision to say that an executor for carrying out his or her duties, they're not going to be liable for anything they do in good faith for you, but they would still be liable if they were fraudulent or negligent through their role as in dealing with the administration. There might be some language around executor remuneration. So an executor is entitled to take a fee for acting. They can claim up to 5% in BC. That's based on legislation. As a one-time fee, and then in addition to that, an annual fee of 0.4%, and that's calculated on the average value of the assets. And but it's a scale that goes down from there depending on the complexity and the time spent and the success that they achieved in the administration. So that executor fee, that 5% is a cap, and then it's a scale that goes down. So some people, depending on the background circumstances of the family and who they're appointing as executor, may, and they may get professional advice to say it might make sense to lock in a fee so that it won't be disputed. And so those are the primary things. You would see some people write in funeral wishes, so whether they want to be cremated or buried or have specific wishes as to what's to happen for their funeral arrangements. A lot of people do that on the side with their executor, though, and don't put it in their wills. But it's not something that's required, but it's something that you can do. So yeah, I'll stop there. I could go
Beautiful.
forever.
And Michael, can you give us a hint as well about what is not going to be contained in that will?
So what is not going to be included in your will typically will be a list of your assets. We don't see people listing out, to say, hey, this is my will, here are all my assets, and here's what I want to do with them. Your assets will form part of your estate and be governed by your will based on how you own your assets. So anything that you own personally will form part of your estate. Anything that you own jointly would typically go to the surviving joint tenant, depending on the nature, the intent of the ownership structure. And registered accounts like RSPs or tax-free savings accounts or RIFs or life insurance, those types of accounts can have designated beneficiaries listed. So it could be that you've designated a beneficiary on those accounts with the intent that the account goes directly to that person or those people. And if that's the case, then those don't pass through your estate. Those are all governed by those beneficial designations or by the joint right of survivorship. So we wouldn't list those assets in your estate, and you wouldn't be directing your executor as to dealings with those assets because they're going to pass outside of your estate based on those ownership arrangements. So we wouldn't see that stuff, and we wouldn't include that in your will.
Super. Thank you so much, Michael. This next question is for Clinton. Before you even go to write your will, what kind of decisions are you going to need to make?
So there's oftentimes a good thought process when you're deciding if it's a time to make a will. So we mentioned in the previous questions, have you acquired some assets or something part of your life where, you think that you want to leave behind once you pass away, and it's specifically to individuals or organizations. So that might be something to consider, or decision making when you're wanting to make a will. Who do you care for? Who do you have to make sure that are taken care of? Again, speaking to young families with kids that are minors, oftentimes those are the first individuals that they think of when creating a will. One thing actually I've noticed that people do not put too much thought in, that should maybe be something that to be considered, is who will be your executor? So an executor in a will is the individual that is the one distributing your estate once you pass away. And oftentimes people don't put a lot of thought in terms of who they want it to be. And that is an issue, because this is sort of one of the main mechanisms of a will, where you are appointing the individual to basically oversee your estate once you passed away, and making sure that this individual or company, which you can hire a company to do that, in your will, are they able to do what you are looking to get done? So that's, I think, another consideration that people do need to consider before writing the will, to ensure that they have these thoughts sort of addressed prior to either meeting with their legal professional or drafting a will themselves.
Beautiful. Thank you so much, Clinton. Brandy, this next question is for you. Who can write your will?
Thanks, Paula. It really depends. And first, I want to mention right off the top that you can't delegate that job to your power of attorney. You have to write your will or give instructions to a professional to write your will. So yeah, so first off, you can absolutely draft your own will. It's probably best to do this if your circumstances and assets are, straightforward. You have a house, you have a spouse, no complicated trusts. There's tons of online and offline resources to help you make a will, like DIY wills websites and blank will forms and do-it-yourself will kits. I noticed there's a couple questions in the chat about which are the best. And I'm sorry, I honestly don't know. Maybe Michael or Clinton would have a better idea, but yeah, I don't know, but there's a whole world of possibility there. But if you have more complicated wishes, you would probably want to get a professional, a lawyer or a notary to draft it. For example, if you have a disabled child, in that case, you would want to ensure that your estate planning addresses the needs of your child. And you want to be extra careful when a disabled child or adult is involved with the estate, especially if there are disability benefits. So I noticed that this was another question as well. And I would just urge you to go talk to a lawyer. And I would say that if you spend the money on professional estate planning on the front end, that can prevent way more time and way more money spent by your estate later on. You may also want to hire a professional like a notary. For example, if you anticipate conflict among your heirs, if you have any unexpected plans, like wanting to leave more money to one adult child than another, you would want to get advice from a professional on how best to arrange that to minimize fighting or issues when you're gone.
Excellent. Thank you so much, Brandy. Michael, this next question is for you. So if you were to hire a lawyer or a notary to write your will, what could you expect that process to be like?
Right. And actually, Clinton, if you don't mind, maybe we can do this one together from your perspective as a notary and my perspective as a lawyer. So firstly, if you're going to a lawyer or a notary to assist with your estate planning, then the starting point is you're getting professional advice. So it's going to be a full overview. It's when we're looking, if somebody comes to me to assist with preparation of a will, I'm not just running through a checklist with them to say, hey, okay, well, you need to choose an executor, you need to choose a guardian, tell me who the beneficiaries are going to be. We'll write it up, you can sign it, and you're done. What we would typically do is we'd say, okay, well, give us your family background. Let's hear more about your family. As Brandy alluded to, okay, do your kids all get along if you have kids, or are there any potential heirs who are in dispute or at odds with each other? We would want to know where they live. Are they local? Are they Canadian residents? Are they non-residents? How old are they? Are they trustworthy? So those types of things. We would want to know, what's the family breakup? Is it a blended family? Do you have kids from previous relationships, or are they all kids of yours and your partners? That's relevant for our law in BC. Because different rules apply to between biological and adopted children versus step children. So that would be really important, just to get a good framework of family background. We would also want to get a good framework of the person's assets, what they own, how they own it. Are there any joint tenancies? Are there any registered accounts? We talked about that. Are there corporate interests, or what's going on with the asset base? Because we would also do an overview on the tax planning side, is to figure out, okay, well, having a will is one thing, but we want to make sure we know what's flowing in the estate that will be governed by your will and what's flowing outside of the estate, and perhaps making a plan to ensure that it's going to be as efficient as possible from both perspectives, from a legal perspective as well as a tax planning perspective. That's how we would do it. Clinton, why don't you jump in and tell me your process?
Yeah, definitely. I'm glad, Michael, you sort of described it in a way where I was hoping you would, where meeting with a legal professional, it's a bit different in terms of a wills meeting with a legal professional than any other sort of legal professional meeting where, for say, let's say example, you're buying or selling a property where, it's, okay, here are the documents, sign here. Here's the mortgage, sign here. Here are the statement of accounts, sign here. Whereas I would describe a meeting with a legal professional for wills as a much more intimate affair, where we are actually going to be sort of diving into your family background. We're going to be talking about relationships between family members. And one thing I do notice is that there are times where clients are actually not prepared for that, where they're not prepared to sort of open up sort of their sort of acknowledgements towards certain family members. And we try to prepare clients ahead of time to let them know that this is how it's going to be, because again, it's very different. It's not like you are going in to do some very rigid legal work. It's a very much a process where we're trying to paint a picture where we want the estate planning to essentially mirror what your wishes are, and that will include diving into sort of those areas of your life. Another area where people oftentimes are surprised with is, going into your assets and confirming your assets of what you have. Many times when I meet with clients, the question is, well, why do you need to know what I have in my bank accounts? What do you need to know why I have properties outside of Canada? So, we ask these questions so that, as Michael mentioned, we can be as precise in our advice to you in terms of what your will should include or not include, and how it should be. So, at our office, our process oftentimes takes about an hour, if not more, where I'm sitting with my clients and basically getting to know them, and basically affirming and answering any sort of questions they may have concerning, if I leave out my stepson, how would that look like? Or if I don't want my spouse to get my estate, how would that look like? And addressing those questions, because oftentimes these questions are not sort of upfront, meaning that you don't think about these things until we start asking these scenarios, and I feel like that's where the benefit of meeting with a legal professional is that you figure out the answers to the questions that you actually didn't know that were there, and that those questions that are answered become very integral in terms of creating an effective will for an individual.
Beautiful. Thank you so much, Clinton and Michael. I think you're painting a pretty clear and realistic picture about what a person can expect when they go to meet with somebody to prepare the will. The next question, and Clinton and Michael, this is also again for you, starting with you, Clinton. How much time and how much money does it typically take to make a will?
So I'll address the time one first. So for our office, oftentimes we have 2 appointments. We have one appointment where we first meet with the client, and prior to the meeting, we've already emailed or provided our sort of information sort of that we want clients to consider prior to coming in. So I don't want to really call it a worksheet, but it's more of a guideline to what things we want our clients to be sort of focused on in terms of when they come in for the first appointment. So it's information such as, again, who are their family members, who are their children, do they have a spouse, do you have assets outside of Canada, inside of Canada, have you been divorced, is this your first relationship, et cetera, things like that. So when they come in, I'm able to sort of dive into those questions and ask the questions that I need to prepare, a will that reflects what the wishes of the individuals are. So the first appointment, as mentioned, is usually about an hour. We like to leave as much time as possible to meet with the client to kind of address any concerns they may have prior to us actually preparing the drafting. And then after the first appointment, the second appointment, we like to schedule the second appointment usually 2 weeks after. And the reason why is because we want, first of all, we need time to draft the will. And then second of all, we want to send the drafts to the clients for them to review and have time to review the documentation and have any questions they may have once the draft will has been provided, so that when they come in for the final appointment, we can address those questions and also execute the will. Now, in terms of costs for will for our office, for one individual, it's 480 plus taxes. And for a couple, I believe it's 600. It's off the top of my head. But oftentimes, we have couples who come in who want to do what we call sort of mirror wills, where they're very similar. And we have a discounted price for that. And so that would be the cost in terms of doing a will in our office.
Super. Thank you so much. Michael, we would love to hear from you.
Yeah, so some of my take is similar to what Clinton just mentioned. I mean, if it's straightforward, then we can often do it in two meetings. So first one to as an information gathering and a mapping out the instructions for the drafts, and then a second one to actually do the sign up. It can take a week. It could take a month. It just depends on how quick people need these done. I find a lot of the requests I get for will planning where it's quick is because somebody is about to go away on holidays and they've realized it, and now they want to have something in place before they go, and they're leaving in a week. So that happens, but yeah, it just depends on how quick people are to, how busy people are in terms of their ability to review their documents and ask any questions they might have, as Clinton said, and make sure that they're good with everything before they actually come in to sign off. So that's the time frame. I mean, if it's more complicated, then sometimes it takes a bit longer because it might not just be one meeting to go through it and to map out instructions. It could be one meeting for information gathering, but then we're looking at things and try to map things out to deal with any complexities. And maybe I would do a second call or write up something with our recommendations, and then we're running through it and mapping out from there. So it can take a bit longer for more complicated situations. In terms of cost, so Clinton is coming in much lower than we would. So we would, if it's someone doing just a will, then it would be around 1,200 plus tax. And then if it's for a couple doing wills, then it'd be about 2,000 plus tax. But almost always, and I'm sure this is for Clinton as well, when we're doing wills, we're almost always doing powers of attorney and healthcare appointments through representation agreements. So it's usually, it's very rare that we just do a will by itself. It's much more common that we do the full package. And so for that, it's about $2,000 for a single person to do a will, power of attorney, and a representation agreement plus taxes. And then it would be around 2,500 plus tax for a couple to do it. So similar to what Clinton said, when we're doing a couple's mirrored plan, it's discounted cost because it doesn't take us as much time to do that second set because they're very similar to the first.
Super. Thank you so much, Michael. It's really helpful. You too, Clinton, as well, just in terms of what the range is and what you can expect. So that's really great. Brandy, this next question is for you. What do you need to do to make your will legally binding?
Thanks, Paula. So in order for your will to be legally binding, there are several formalities under the Wills, Estates, and Succession Act. So first, the will maker must be, I think it's over 16, actually, over 16, but it's different in different provinces, and must be mentally capable to sign the will, and you can't be pressured to sign a will. Your will must also be in writing. A physical will must be typed or handwritten. What's interesting is that now your will can also be in electronic form, like a PDF, for example, recorded or stored electronically, able to be read, and capable of being reproduced in a visible form. So it can't just be a recording of you making a voice note saying your wishes. Your will has to be signed on the last page by the will maker in front of 2 witnesses. And if you're doing an electronic will, it can be an e-signature. The 2 witnesses must sign the will in front of the will maker. And what's also interesting is that your 2 witnesses no longer have to be physically present. You can be in each other's electronic presence like we all are right now. Let's sign some wills. That really broadens the range of people who can be your witness. And you must be able to hear and see each other and communicate simultaneously, like if you were all physically present, like by Zoom. And you must sign identical copies of the will. Also, your witnesses should not be beneficiaries under the will or the spouses of beneficiaries. Under the Act, gifts to witnesses or spouses of witnesses are void. However, I want to point out that after you're deceased, the witness may ultimately apply to court, and if the court's satisfied that you intended to make the gift to them, the gift won't be void. So it's curable, but unless it's absolutely unavoidable, just get someone who's not a beneficiary or their spouse to witness your will. So similarly, and I see a couple questions about this in the questions about, like unsigned documents that are in a safe, that kind of thing. So under the Act, under the Wills, Estates, and Succession Act, your executor can ultimately apply to court to cure deficiencies of your will when you're deceased. So like if there's, you know, only one witness or no witness, things like that, if there's sufficient evidence of the deceased's testamentary intentions. But I caution you that you don't want to make your executors have to rely on that and go to court. It's best to educate yourself now to learn the requirements of a legally binding will and save your executors and beneficiaries the time and the money, and that's your money, and headaches when you're gone.
Super. Thank you so much, Brandy. Michael, this next question is for you. If you follow all of the technical steps, are you assured of leaving a will that is valid?
Any will can be challenged for its validity. So you can run through all of the formalities correctly and sign a will, but depending on circumstances, if somebody, you know, is suspicious, then there are ways to invalidate that will through a court application. And the common ones are, number one, is it would be a challenge to the will maker's capacity, to say that the will maker did not have the mental capacity to sign the will. And there is a test laid out in our common law for what the elements are in order for a will maker to be deemed capable of signing a will. And very loosely, you know, it would include things like the will maker having a good sense of their family background, who it is that they are obligated to provide to by our law in BC, and who they are providing to, that they're giving their assets away on death. They have to understand that that's what they're doing by signing a will. They have to understand what their assets are. And that's really the base of it, is that they understand they're disposing of their assets on death and how they're doing that, and who it is that they're otherwise obligated to provide to. So that's one. And then so if somebody feels that a will maker did not have capacity, then it could be an application to the court to say that the will is invalid due to lack of capacity. And then it's a litigation proceeding to determine whether the person in fact did or did not have capacity. And lawyers can assess capacity. I actually don't know if notaries can assess capacity. Clinton, do you know the answer to that?
Yes, we do. We do assess capacity as we have to draft and create the wills. Yes.
Right. And then so lawyers can do it, but then of course we can have evidence as well to back it up. If I have a situation where I'm dealing with an elderly person who has potentially limited capacity, and I do an assessment, or perhaps it's one of their kids or other family members that's reached out to me and asking me to help, I might have them go and be assessed by a physician or a geriatrician first. If there's, you know, what they're trying to set up in their will could be challenged, then we might want that further backing from a medical practitioner, and that medical assessment, if it comes back to say the person is capable, would be a piece of evidence to use to promote the validity of the will if there was to be a challenge down the road. So that's something that we would do in certain circumstances. The second way that a will can be challenged is through undue influence, we call it. So that's where there's potential evidence to suggest that someone has really pushed the will maker into signing the will as it reads, and so where the will maker perhaps did not voluntarily make the will him or herself. And same thing. I mean, it's something where you have to build up evidence. You need the evidence to support the claim. But if it's successful, then where a court would determine that there was undue influence by someone on the part of the will maker, then in that instance, the will could be deemed invalid. And if a will is invalid due to incapacity or undue influence, then it's as if it never existed, and the previous will, if there was a previous will before that, would be reinstated. Or if there was no will, then the person would be deemed to die intestate, and we'd be relying on our legislation in BC as to succession of assets and rights to take on the role of administrator.
Super. Thank you so much, Michael. This next question is for you, Clinton. So let's say you've gone through the steps and you've got your will, it's signed, it's executed. What do you do with your will after it's been signed?
Yeah, so there's sort of various options in terms of what you can do with it. So obviously you want to make sure that you keep it in a safe location. And so in our office, we oftentimes recommend two locations. One is a safety deposit box at the bank. And the reason is because that's usually a location where, if you are moving, or if you're, not a person that is good with keeping legal documents around and making sure that you know where they are, the safety deposit box is a good location because it's sort of just always there. And that if your executor, once you pass, your executor can contact your bank and basically notify them that the will is there and have access to that at that time. The other location that clients oftentimes will do, obviously, will keep it at home, and we do recommend a fireproof safe location where, in case if there's any big accidents, that the will is preserved. And so those are the main ones. Now, as Brandy mentioned, now there is sort of the emergence of digital wills, and there is oftentimes the ability now to store wills electronically, and sort of usually in a server or in a secured location where it can be kept in, and that the executor, when time calls upon them to do so, to obtain the will and use that will for the purposes of probate or other methods. So those are the sort of what you do with them after it's where do you put them in a way. And oftentimes in our office, at least, we do recommend registering your will with vital statistics with the wills registry. And this is where you register the last known location of your will, so that if anything happens, your executor can look it up to see where the last known location is, and basically see if the will is still there at the time of the person's passing.
Super. Thank you so much, Clinton. Brandy, this next question is for you. What if you want to change your will after it's been finalized?
Good question. Thanks, Paula. I think there's kind of a misconception about wills as this like monolithic, intimidating thing. You're kind of scared and you're intimidated to make your will in the first place, and you feel like that's it, that's your final will for forever. But a will is not a static document, it's a living document. I think you shouldn't look at it as a once in a lifetime thing. I think, like I said earlier, you should make a will when you become an adult, try to anticipate your eventual life circumstances, but then don't be afraid to make a new will. I think you should always have a will that reflects your circumstances. And I think the three of us, Michael and Clinton, frequently see in our work the consequences of people passing away with wills that don't plan for either their financial or personal circumstances upon their death. They haven't actually anticipated what would happen at their death. And like I've said before, the consequences of that are money and time spent by their executors and headaches for their beneficiaries or their would-be beneficiaries that they accidentally left out because they didn't anticipate their personal circumstances at their death. So how do you change a will after it's being finalized? A couple of options. If you have a hard copy will, you can make changes to it by signing a separate document called a codicil. And I think I saw one of the questions in the chat about this. A codicil is a formal document used to modify or supplement a previously executed will. And it would allow you to make minor changes to your will without invalidating the entire will. Codicil has the same legal requirements as a will, witnesses, signatures. I would say it may be a good idea to seek professional advice when making codicil to make sure that you don't accidentally put inconsistent, ambiguous clauses into the codicil that are difficult for your executor to interpret later on. And a codicil is, good for making minor adjustments, like adjusting gift amounts, but for more comprehensive changes, you may want to just make a new will. You can revoke, cancel your old will, and prepare a new will at any time. If you have an electronic will, the only way you can change it is by making a new will. So if you make a new will, I'd point out to include a revocation clause at the beginning of the will to revoke your prior wills and codicils. And I also want to say the People's Law School, I have to say, has a great little webpage called Changing or Canceling a Will. And it's got practical details on giving your executor a copy of your new will or codicil, registering your new will or codicil. So, you might want to check that out as well.
Thank you so much, Brandy. And Yes, the People's Law School does have a number of web pages on this topic and on much of what we've covered here today. So I do encourage anyone who's interested to check out the website. I think you'll find lots of great resources there. This is the last prepared question that we have. Then we're going to turn to the live Q&A. Michael, this question is for you. What happens if you misplace your will and nobody can find it after you're gone?
Sadly, it does happen, and I see it in my practice, and it's a bit of a headache and nuisance, but so the answer is, if you've lost your original will and then you've passed away, then there's a bit of a kind of a second question: is does someone have a copy of the will, or is there no copy where the will is lost and nobody knows what it even said? If it's completely lost and there's no copy of it, then there's nothing you can do. It's at the end of the day, you would somebody would be applying to the court for a grant of administration to gain authority to deal with the estate. And if there's some record that there was a will, as I think Clinton had mentioned, we do have a wills registry through Vital Statistics BC, confirming when people sign their wills and where they're located. So if there's some kind of record to show that there was an existing will, but nobody can find it, and there's no copy, then yeah, somebody has to apply to the court to gain authority. They would let the court know, we tried to find the will, we couldn't. So now we're proceeding on an intestacy. And so that's one. If there is a copy of the will and just nobody can find the original, then you would have to be, the executor would have to take steps to determine, was it revoked? Did the will maker revoke the will, or is it just that it can't be found? But otherwise, to the best of our knowledge, the will maker would want to uphold this will. And then if it's the latter, they can take the copy and they can apply to the court to obtain a grant of probate over the copy of the will, which gives it a validation. And then the executor would have proper authority to do all the things that they need to do in the course of the administration using the will copy. And that does happen more often than you think, where we have to apply to the court for a grant of probate of the copy of the will. And when we do that, we just end up providing, having to dig up a little bit more evidence to support that the will was never intended to be revoked, that the original was never intended to be revoked, in which case the copy can be instated for probate.
Super. Thank you so much, Michael. We're going to turn to the live live questions. The first question I'm going to read out is from an anonymous attendee. I'd appreciate your thoughts on hiring a trust company or similar to be my executor as opposed to naming my adult children. Does anybody feel comfortable taking this question?
I can, and maybe Clinton can too.
Yeah.
Clinton,
Michael,
do you want to?
You go first. You can go first.
So, well, Clinton can kind of weigh in from his side and his practice. What I'll say about that is what we're seeing more and more people appoint trust companies. Mm-hmm. A part of it will depend on where people are located, because there are lots of trust companies that are based in Vancouver and the Lower Mainland area, and some of them will operate in various kind of more rural areas in BC, or just not in the Lower Mainland. But some of them won't. So it depends on where people are. And I know that people are attending this from all over BC. So people that are in the Lower Mainland or in more urban areas, typically the trust companies would be happy to work with you. And it's the benefit of having a trust company do it is, for starters, they're not going anywhere. You could appoint them, they're going to be there. You have the will in place for 20 years, and it's most likely your executor is fixed. Whereas if you appointed an individual, you never know if that individual is going to be willing to act in 10, 20, 30 years. And maybe not. And maybe they're going to be older at that point. And I get lots of people that come in and say, hey, I did a will 10 years ago and I appointed this person, but now this person is 85 and retired and doesn't want anything to do with it. So I need to change. I need to change it. Appointing your kids is fine. And we see that all the time. People appoint their kids. It's just, it can be problematic if the kids are outside of Canada, because it's ideal to have a Canadian resident administering your estate. And And it's also problematic if your kids, if there's any chance that they may squabble. So if they either don't get along, so if they don't have relationships, or if there's any suspicion, or if you felt like your kid would feel that being an unequal treatment in some way, then sometimes having a third party executor, often a trust company, just takes away that issue altogether. Where then, you know, we do see it all the time, where one of the kids has been appointed as executor, even if that child does things exactly perfect, the other kids just aren't, you know, they have a different role as beneficiaries, and it can create, you know, tension and suspicion, and turns into issues that, you know, us lawyers end up having to deal with. And it does raise costs if those issues are larger issues. And so there can be benefit. But if your kids get along great, and you would expect there not to be any issues, then and they're local, then I think it'd be fine to have your kids act as executors. Clinton?
Yeah, and
Over to
just
you.
just piggybacking off of Michael said, we are seeing a larger emergence of people using trust companies, and for our office, one of the reasons is because really there's no one available. All their friends are in their 80s, 90s. Their children are not available, or they don't have any children, and they just want to make sure that their assets are given to a charity or given to an organization or given to a friend, and they really have no other options. And that's actually becoming more and more of a reality as, you know, someone grows older and their friends and people around them are older and unable to act as executor. And so having a trust company alleviates that issue of having someone to deal with the estate, ensuring that it gets distributed according to what they want, the willmaker wants. Now, I know Michael spoke a lot about the positives in terms of using a trust companies. There are definitely some of the negatives that some people may bring up. And one of the major factors is that, actually two major factors, is that it can be costly. A lot of trust companies do actually have a minimum for an estate in order for them to act. So meaning that they won't act unless the estate's worth a certain amount. And so that could be a factor when a willmaker decides to choose a trust company. Another factor is that, and people don't know this, is that oftentimes trust companies or bigger or established trust companies will require certain language in their will put in, and there's no option for the willmaker to object, meaning that if they use the trust company requires the will to be tailored in a way where there's certain clauses that is required, and the willmaker cannot object to these clauses if they are to use the trust company. So that's another thing I find when clients come to us and they ask us that they want to use trust companies, and we draft it and we get the clauses in there, where at that stage the client was unaware that this was a requirement. And may cause them to change them to decide to use a person rather than a trust company.
Super. Thank you both. Brandy.
Can I just say, your guys' answers are so excellent. And I agree with everything you said. And I just wanted to add that, yeah, just do consider the value and experience that a trust company would add as well, because this is what they do every day. So there's that. And just and also, though, of course, the fees. And just one more thing, the public guardian and trustee is also a body that could be named as executor in your will, but just like a trust company would have to be consulted beforehand, would need to review the draft of the will prior to execution, and would also take statutorily mandated fees. But that, you know, could be another potential option.
Thank you so much. This next question, and Brandy, you may I'll offer it. What happens to your possessions if a person does not have a will?
That is a good question. So if a person, if a person dies without a will, there is a statutory scheme set out in the Wills, Estates and Succession Act. And you know what? I think you can go look at the legislation yourself, but I think I've also set this out in one of our 3 previous webinars. But there's a whole level of tiers that your assets and your things will go to. You know, if you die with a spouse, it'll go to the spouse. If you have kids, it'll go to spouse and kids. There's a whole series set out in the legislation. And the bottom line is you can't choose, if you die without a will, who gets your stuff. And that's another reason why it's really important to make a will.
Beautiful. Thank you. Here's another question. If an elderly relative has an outdated will, but when they go to get it updated, they're not deemed to have capacity, how is that handled?
So I guess I'll touch upon it first. So as we're going through the first wills interview, if we have identified that there may be a capacity issue for our office, we like to make that clear and make notes confirming that we think that there may be issues of capacity, and then we may require, and Michael mentioned in his office, require a second opinion, where we may ask for a doctor to provide a written note confirming that they have done an assessment and confirm that capacity has been is within that individual. And capacity is such it can be a very fickle thing because capacity can appear one day and not the other. And when I mention that is in scenarios, for example, in dementia or any illnesses of the mind, some days the person can be full capacity. They know what they're doing. They answer all the questions. They can answer everything correctly. But on the second day, it's just total opposite. And so that's why it's very important that when we do meet with our clients, that we are confirming capacity. So to answer the question, is most likely we would say, unfortunately, we can't do this update. We want a second opinion from maybe a medical professional to confirm that capacity is there, and have another appointment to basically maybe a better day where they can come back and go through this again to ensure that we are almost 100% sure that the capacity is there for this individual.
There's another question that has a number of upvotes. How do you set up a trust fund for someone with a disability?
Sure, I'll jump in.
Thank you, Mike.
So as a starting point, if we're, because we're talking about wills, if a will maker has a beneficiary who has a disability and receives disability benefits from the province, then yeah, maybe it makes sense, and they want to give to that person. Perhaps it makes sense to establish within their will what's called a testamentary trust. And so that would be saying, let's say they wanted to give 1/2 of their estate to this beneficiary. The trouble is if they give it to them outright, then, and then they die, then that beneficiary receives the value. And with that value, they'll no longer qualify for their benefits. And so the benefits will be cut off. But if it goes into a discretionary trust, rather than going outright to the beneficiary, then they can continue to get their disability benefits, and then they get a top-up support through this trust. And how the trust would be set up would be through the will. So the will maker would say, okay, I want to give 1/2 of my estate to this beneficiary, but it will not go to him or her outright. Instead, it will go to this person as a trustee to hold in trust for that beneficiary, where the trustee has all the discretion to allocate income or capital of the fund for the benefit of that beneficiary. And then on that beneficiary's later passing, any balance will go, in this way, however it is that the will maker wants to do it. That's what the trust is. It's a testamentary trust. So you'd be writing it today within your will, but it's not effective unless you pass away. So it doesn't kind of become effective until death. So that's how it would be set up. But then if the question really is, you have that, and now it's a matter of taking the will and setting up the fund, then how that would work is, will maker's died, executor kicks in and is dealing with the administration of the estate. So the executor will perhaps go through probate and to give them proper authority, and then they'll collect all the assets, they'll pay all the taxes, and then they'll take the balance and they'll divide it into the shares as it's set out in the will. And one of those shares will go to the trustee to fund that trust. And then the trustee will take the will, the probated will, and they'll go to the bank and they'll say, hey, I need to set up an account, a trust account based on this trust that I have here that's established in the will. And then now you've got the account set up and a place to put the money. So that's kind of roughly how it would work. And it's a separate entity that has to file tax returns every year. So it needs a tax number. And then of course you'd be getting an investment advisor involved as well if you wanted to arrange some kind of investment program for the funds while they're sitting there.
Beautiful. Thank you so much, Michael. We are pretty much at time. I'm going to ask one last question, and then we're going to go to our last slide and wrap up. There are a lot of questions in the Q&A about will kits. And so we touched on this briefly in one of Randy's questions, but Michael or Clinton, if you have any particular will kits or any criteria that somebody might look at when considering what type of will kit to go for, that would be quite helpful.
That's an interesting question, just because will kits are very in my mind very rigid and very cut and paste and very not customizable as what you would think. And it really relies on the will maker's knowledge or reading of certain things in the will kit to draft their will. Now, if you are like Brandy mentioned, if it's very straightforward, you're just everything to my kids, there's no other things that need to be considered, and you have one executor and that's it, by all means a will kit is very very handy for you to do. But the caveat with that is that I would say most people's lives are not that straightforward, especially nowadays. One experience I do get whenever clients come in, the first thing they say is, oh, it's very straightforward. We're going to get this, it's going to be very easy for you. It's going to be 15 minutes tops. And I sit with them for the full hour. And I address those questions or concerns that were never even thought about. And then that's where we go from. And so to answer the question, no, I don't have any recommendations of will kits. I know they're available. Libraries have sort of books that you can read upon. So I would strongly suggest educating yourself first before attempting a wills kit. It's not just something that you can take and fill in names and rely on that, that's everything in terms of what you want to happen to occur.
Here's what I'll say about the will kits, if that's a key point here. As I have seen those wills, I act for executors to do administrations and probate applications and all that. So I have to deal with the back end of these things. And I've seen, some do-it-yourself wills where it ended up working okay. And then I've seen many where it did not end up working okay. And maybe it's a 50-50 shot. And it's not that the will itself is a problem. Oftentimes, the will is very bare bones, but it's passable as a will. The problem really is that nobody has got advice around what's happening in the outside of the will. What's happening with the actual assets? How are they owned? Are they going through the will or are they not? Because often what happens is somebody's done up this will thinking all their assets are going to be governed by this will, but then little did they know, because they never got advice, that they have some joint property with their son or daughter, and it turns out that might not go through the estate, depending on the background, and then that turns into a dispute, or it could be a number of different things, or they've named someone as a designated beneficiary. They name one kid as a designated beneficiary on their registered accounts, but they have 3 or 4 kids, and now the question is, well, what was the intent of that designation? Was it for that child to get those funds, or is it supposed to form part of the estate? And then you're dealing with the question, and it's a dispute, and that needs to be addressed. Sometimes families are really good, and they work through those disputes simply, and everybody just agrees with what mom and dad's intent was. But more often than not, it turns into a problem, and then it's getting into the tens, 20s, 30s of thousands of dollars to address that dispute, and sometimes even hundreds of thousands of dollars. So yeah, it's much simpler to make, going to a professional. Clinton and his group's cost is very reasonable. We're fairly reasonable, I think, as well. I mean, to pay a few $1,000 or $1,000 to a few $1,000 to avoid a potential $100,000 legal bill, to me is a no-brainer.
Mm-hmm.
Absolutely. And to make sure that your intention is being followed after the fact. So thank you so much. That's such great insights. Brandy, we would love to hear from you if there's anything that comes up that you'd like to share that we didn't perhaps have a chance to cover.
I just can't agree enough with what Clinton and Michael said, and most of my work is done in the back end, and I really emphasize spend a little bit of money on the front end to save a significant amount of money coming out of your estate.
Mm.
The money you earned on the back end. Even just small things that you would not occur to you, like setting up a trustee for your grandkid, things that wouldn't occur to you. A notary or a lawyer it's just part of their standard things that they ask you. They're going to ask you. It's not a big deal for them. You'll set it up correctly on the front end. So I absolutely would urge you to go seek professional advice. Yeah, thanks so much, Paula. This is a helpful session.
Beautiful. Thank you all. And thank you, Brandy. Thank you, Michael. Thank you, Clinton. It's been such a pleasure having you back for the 4th time in the past 4 years. So such a pleasure. And thank you to all of our guests for joining us here today. It's been amazing having you. Thank you for your questions and your participation. We hope to see you at our upcoming webinars, and hope everybody has a great Make a Will week, and that this webinar has inspired you to take that next step. Thank you, and we'll look forward to seeing you again soon.